So over the last 3-4 years, this stuff hasn't been around that long, suddenly I found myself entrenched in issues relating to online XYZ. And today's topic, as advertised, is all about online copyright issues. So what I'm going to try to cover, and I don't take credit, this is a fabulous presentation, but I did not write it, so if I look like I'm stumbling on it, you can blame Josh and Rashawn. And I'll call on them as we go through it. But at any rate, the overview of copyright law. What is it? Some of you may have an idea, some of you may be confusing it with other areas of intellectual property like trademark and patents, and when do you use the word copyright versus a trademark or a patent. And then go into some of these social media sites. The most popular, of course, are Facebook and Twitter, and kind of analyze the terms of use as it applies to copyright law. And as we know, Facebook, for example, changes its policies as it pleases every so often, and there's a lot of watchdog groups that kind of keep them in check as well. But as of now, we can kind of cover broadly issues like, does Twitter, Facebook own my content? Can I sue Facebook or Twitter for someone else's infringement of my content? What happens? Who owns all the stuff that goes out on the internet? We're going to talk about the DMCA, the Digital Millennium Copyright Act, which is a safe harbor provision, and I'll go into it in more detail, providing Facebooks and Twitters with liability protection from claims of copyright infringement. And a lot of you asked about posting and sharing news stories. I think we have our marketers in the house. Hey, introduce yourself, Lisa.
Sorry, hi, Lisa Gasol, Lisa Design.
I think we have some extra chairs here, and Michelle can grab some more from back there as well. So come on in and get some food. Before I start, has everyone gotten pizza if they want pizza? If not, please, I'll take a 2-minute break. Go get it, because it's going to get cold and gross, and that would be sad. All right, so I will start. We all know what we're going to cover. That's everything. Let's start with the basics. Dave, you have a seat? All right, so how many of you know what a copyright is inherently? Okay, so does anyone need a kind of a refresher? I'll give you a 2-3 slide refresher on what copyright law is and what it isn't. So at its core, copyright law is a set of exclusive rights given to an original author to regulate the use of a particular expression of ideas. That's the legal jargon. What it is, it's your photos. It's the rights you get to own your photos, your music, your written content, anything that you've created. What it's not is it's not a logo, it's not a source identifier, and that's what trademark law protects. Trademark law protects the brand name of something. So, give me a business name, Very Chill. Very Chill is the trademark, perhaps the art or the website or the content or the music that Very Chill uses, that would be subject to a copyright. So, brand, content, that's the distinction between a trademark and a copyright. Patent, sometimes people use interchangeably. A patent only relates to the idea for doing something. So an invention, the way a business method, the way a device works, you know, kind of going through the patenting process, right? So those 3 areas of law broadly are referred to as intellectual property law. So when you hear about protecting intellectual property, it's covering copyrights, trademarks, patents, etc. Trade secrets, it's like the brother of these 3. And it talks about things that are proprietary but aren't necessarily protected by copyrights, trademarks, or patents. When can you get a copyright? Technically, you own something as soon as you create it and you fix it into what's called a tangible medium. Me talking right now, is that copyrightable?
Words, no. Presentation, yes?
Yes. Presentation, yes. But what about the video?
Yeah.
Yes. Who owns the video? Me or the person taking the video?
The person taking it.
The person taking the video. I'm doing all the work here. I'm talking, I'm up here, but at the end of the day, the person who took the video can go off and do whatever they want with me talking. So that's something to think about. And we have a lot of lawsuits in-house about, well, I gave the idea and I hired this person to create it and I was telling them what to do. But if they're not the ones videotaping or writing or creating, then they're not the owners. So I will touch on ownership as we go through, but it's very important to understand ownership as it relates to copyright law. Again, I may be all over the place, so stop me if I'm not clear. All right. At its core, this is what you are licensing or requesting permission to use if you're or giving or granting permission to use if you're a copyright owner. You get the right to make copies of your work, the right to prepare derivative works, which means if I write a poem and then I want to write a full book about, based on the poem, or if I have a book and I want to make a movie based off the book, the movie is the derivative of that book. So I am the only one who has the right to make that movie. That's why you buy story rights or option. You've heard about the rights to a movie, the rights to whatever. That's because you want to have the right to create that derivative work. You have the right to distribute copies, the right to perform the work, and the right to display the work. So this is the crux of everything that goes on online. These are the rights that Facebook, YouTube, any social media site, any site is requesting a license or permission to use. And on the other side, if you're the content owner, you're the business that has web content or photos or images, these are the rights that you are protecting and may selectively decide to allow others to use. Okay. They are your rights. They're your rights automatically, but they're worthless if you want to sue anyone for it. This is little known fact. So copyright law, yes, putting a little circle and putting copyright notice 2011, that just puts people on notice that it's your work. But if someone rips you off or infringes on your content, you will not be able to sue them or get any money for that infringement unless you file a copyright registration. Okay. Yes?
Just a quick point of clarification. So, as I understand it, when I upload a video onto Facebook or YouTube, the second I upload that, I give up my right to that material because now they own it as the host, correct?
Not correct.
Not correct?
Not
okay,
correct.
That's good news.
That goes to this question. Does Twitter, Facebook own my content? And so, if you want to talk about it now, we can talk about it now. But let me just finish what, actually, I'll talk about it. Remind me if I don't cover it, but I will cover it. Yeah.
No, just to clarify, so I was under the impression that the common law rights gave you the right to sue but not get fees. You're saying you actually don't have a right to a lawsuit if you haven't registered?
It's now, that was like 30 years ago.
Okay. I'm an older guy.
No, right. So it's purely governed by federal statute now, and you can only bring copyright claims under federal court. And in order to bring the claim, lawyers, you need a registration.
So you'd actually be subject to a motion to dismiss if you tried to do it without registration.
And that's what the first time now many of you will not get registration for your website content. And someone rips off your content, and then you call me and you're like, God damn it, what do I do? So you can then file a registration and file suit, but what you lose are these lovely statutory damages and attorney's fees. So if you file your registration more than 3 months after you put the content out to the public, or if you file the registration after the infringement has taken place, you can sue, and you can sue for maybe actual damages or lost profits that the other person made, it goes both ways. So the profits they made or your damages. But you will not get to take advantage of what are called statutory damages. The Copyright Act is one of the few in our American legal system that gives attorney's fees to the person who brings the suit and wins. So if I'm a copyright owner and I sue because I've registered in time, the person who loses could have to pay my lawyers, whatever, fees. And the minimum amount of damages per infringement is $750 up to $150,000. Which was when, if you remember the recording industry cases, when they were suing for downloading music, and you heard about these big judgments, it's because if I download 10 songs, 10 times $150,000 can be a lot of money, right? Yeah.
If you wait till, say, a year after you go online, but sue immediately upon the infringement, can you get the fees?
You cannot get statutory damages. You can get fees, but practically, let's give it in the context. I have pictures on my website. Maybe they're not really that valuable, but they're valuable to me, or I have catalog photos, or whatever. I have just a picture of myself on the website, and someone takes it and puts it on their site. I can sue for actual damages, but what are my actual damages? I'm going to have to pay someone to identify what the cost to me of that infringement was. If I have registered in time, I just go and sue and scare that person with the statutory damages, minimum of $750 up to $150,000. So registration is really important. Everyone knows what copyright law is, but everyone has this false sense of security because they think that that Circle C that they slapped on is enough to give them protection in their work.
And that's within how many months?
3 months. So another question I always
From
get
the time you published it.
from the time you published. What's the question?
I was going to ask the same thing you just said. Was
From
it
the time you've
creation or publication?
Right, now if you've unpublished works, then again, it's not published, so people don't know. But it has to be before infringement. So you can't wait afterwards to get these statutory damages. Yes.
Is every change that you make to the website a new publication that starts your 3-month clock?
The new stuff would not be protected. Well, yes and no. You have the right to sue for someone making derivative work. So if I own the book and you made a movie and you didn't ask my permission, the registration for the book would be enough for you to get the damages that you're seeking.
If I have a website
Yes.
and it's not music, it's just narrative,
Yes.
then I make changes to it.
Yes. You are the owner of the changes, the derivatives. So technically,
So the derivatives don't relate back. I can't change one page and bring back in my original 30 pages. My original 30 pages that I didn't register after 3 months, I can't go back and save it. Or I can't.
yeah, you can. This is getting a little too. We have a lot more stuff to cover, but we can. But the end of the story, or the takeaway, is that derivatives are owned by you, so you can sue if someone copies even part of it. If you have if you even don't even necessarily need to copyright the final product, it's just extra protection. With things like websites that are constantly changing, then you want to file a new one every 3 months to cover the new content. That's why new media can be complicated. Now, you can try to do the catch-all because you can say the new content was a derivative of the old content, but if there are clearly different articles and they were published in different dates, then they would need a new registration. Does that answer the question? Right, that's copyright law in like 30 seconds. Obviously, it's a huge body of law. I can't go into everything, but before we go to fair use, the question about who owns it, does Facebook own it? Whatever. So you are all the owners of the content that you create. When you upload it to social media sites, it's very important that you read the terms of those sites, because one site may try to own everything, but the majority of these sites, including Facebook and Twitter, what they ask for is a broad license to use your content however they may choose. What's the distinction? So if we go back to this, Facebook, by its very nature, is displaying your work once you upload it. And that's technically an infringement, because you own your work and you are the only person who can display the work. Now, you're using their site to display your work. Now, Facebook, they want to make absolutely positively sure that you're not going to sue them for copyright infringement by doing any of these things. Inherent in the site is people are making copies between profiles, maybe someone's making a derivative through some sort of application, whatever. So to cover their own butts, they get a very broad license to use your content. A license is different from an assignment because they don't own it. They're renting your house. When they're done renting it, and in fact, if you felt like it, you can have 20 people renting your house at the same time. The other renter may not like it, they may not rent from you, but you could say 20 people can live in my house right now if I wanted them to. Assignment says, I'm selling you my house. If I have a photo, and if Facebook said in the words, read the terms of use, if the terms say you are assigning to me the rights to your content, they're taking from you and now own the content. So if you look at terms, most of the time they're going to say a non-exclusive, broad, and I had it in the presentation, but I think I took it out, but we can pull it up at the end. But then the keywords are exclusive versus non-exclusive. What does exclusive versus non-exclusive mean? Exclusive means they're the only one who can rent your house for a year. Non-exclusive means we're one of the 20 renters in your house. Perpetual means forever. The rental term is I can squat in your house as long as I want, as long as I pay rent. Or not squat, but I can live there as long as I pay rent. At any rate, so it all goes back to these set of rights. Now, as a right owner, I might say, you are allowed to make copies of my work. I'm giving you a limited license to just do that. But I'm not letting you do this other stuff. So you can parcel these out. Or I'm allowing you to do all of these, but you can only do it for 3 months. After that, your license to use my work stops. And that's what lawyers do, really. They're negotiating these set of rights in the context in which you're allowing people to use them and not.